Welcome back to the High Court Report. We come to you this Tuesday, November 25th, just 2 days from Thanksgiving. I hope everyone travels safely to their destinations. In today's episode, you'll hear highlights from the November Supreme Court cases. I tried to capture multiple questions from each justice. I included chapters for each case so you can quickly skip forward and backward if any particular case or cases especially interests you. You can find us on Apple Podcasts, Spotify, YouTube, and wherever you get your podcasts. Just search the High Court Report. And remember, if you liked the episode, please follow, rate, subscribe, and share. Let's dive in.
So you're not arguing that your motion, your 60B motion, was filed within a reasonable amount of time?
We believe, Your Honor, that there is no reasonable amount of time within which a judgment that is void ab initio can be vacated.
And how is void ab initio different from the grounds listed in 60B, the judgment is void, that as a basis for the motion?
We believe, Your Honor, that a 60B4 applies to both void judgments and voidable judgments. And so when a judgment is voidable, there is no reasonable time limitation because at that point the court that had entered it had jurisdiction, and for some other reason the judgment should be held void, as opposed to a void judgment which has no legal effect right from the beginning.
So how do you respond to respondents' argument that you're conflating the merits with the timeliness of the motion?
Well, we believe, Your Honor, that if a judgment is void ab initio, there is no timeliness aspect that would should cause a court to not vacate that judgment.
Suppose a district court issues a judgment that is void ab initio, and the party against which the judgment is entered waits a year before filing a notice of appeal. Would the Court of Appeals be obligated to entertain that appeal?
I think it would, Your Honor, because at that point the appeal, the filing of the notice of appeal is tantamount, or is not tantamount, would require an appearance before a court and would result in the appearance before the court would result in submission to the jurisdiction of that court.
What about fraudulent judgments? Do you think that they can be challenged at any time as well, or there's no ground on which they can be reopened?
Well, I believe fraudulent judgments are covered by Rule 60b-3, which requires which must be filed within 1 year. And so that timeliness aspect applies through Rule 60c-1 as well as Rule 60b-3.
Well, I guess I'm a little concerned about the potential collapsing of the merits with your argument in this case, because your argument, as Justice Alito pointed out, is premised on the fact that this judgment is actually void, but obviously the person who benefits from the judgment would say it's not. And so some court somewhere, I think, would have to resolve that. And I guess the question is, why should you be able to make that kind of challenge without any sort of procedural limitation in terms of time? Someone has the judgment who's benefited from it, and they are living their lives and thinking everything is fine, and under your rule, that can be upended at any time on the basis of your claim that that the judgment is void. Don't we have procedural rules that sort of just limit your ability to make that claim and really don't speak to the issue of whether or not it's actually void? You just have to make that allegation within a particular period of time.
Justice Jackson, I would say that void judgments or judgments void ab initio are within a separate class. And so the Constitution requires that void judgments not be given effect.
You're asking us to rule that way
Right.
because you say there's a common law. But if there isn't a common law, because there were latches applied by some courts, not all of them, but some, doesn't that defeat your argument?
I would say, Your Honor, that it would not defeat the argument, because if the court were to find that a void judgment cannot be given effect for due process
You're going
reasons,
around in a circle. We can only find that if there really is a common law rule and Rule 60B doesn't override it, because common law rules can be overwritten by 60B.
correct. And so
if we look at what the advisory committee said when it was creating 60B, was that it wanted to, because the existing rules in common law were, quote, unquote, confusing, one of the purposes of the amendment was to clarify the rule so that the federal rule will be controlling. So what do we do with that?
well, because the enforcement of a void judgment, even to overcome latches, would require a violation of due process.
Could Congress write a rule that says exactly what you want? Even void judgments need to be filed within a reasonable time. Does Congress have the power to do that?
I was going to say, Your Honor, I don't think Congress has that power because the Constitution, because of the Due Process Clause. And so if the court were to find in Coney Island...
You're asking us to rule that way
Right.
because you say there's a common law. But if there isn't a common law, because there were latches applied by some courts, not all of them, but some, doesn't that defeat your argument?
I would say, Your Honor, that it would not defeat the argument, because if the court were to find that a void judgment cannot be given effect for due process
You're going
reasons,
around in a circle. We can only find that if there really is a common law rule and Rule 60B doesn't override it, because common law rules can be overwritten by 60B.
correct. And so
if we look at what the advisory committee said when it was creating 60B, was that it wanted to, because the existing rules in common law were, quote, unquote, confusing, one of the purposes of the amendment was to clarify the rule so that the federal rule will be controlling. So what do we do with that?
well, because the enforcement of a void judgment, even to overcome latches, would require a violation of due process.
Could Congress write a rule that says exactly what you want? Even void judgments need to be filed within a reasonable time. Does Congress have the power to do that?
I was going to say, Your Honor, I don't think Congress has that power because the Constitution, because of the Due Process Clause. And so if the court were to find in Coney Island...
But you gave up constitutional arguments in your brief.
I'm sorry, Your Honor?
You gave up constitutional arguments in your brief.
I think we didn't give up constitutional arguments. We gave up an argument that Rule 60C1 itself is unconstitutional. But the Due Process Clause still exists, obviously, and so we would say that the Due Process Clause would require an overriding of a latches argument.
Is there a way to challenge a void judgment beyond Rule 60?
We don't think so, based on the text of the rule and the history. The rule itself is pretty expansive. It says it is the way to get relief from a valid judgment, and the history is pretty clear. The advisory committee notes, which are codified, says it's obvious that this is the only way to get relief. We're trying to, close the door. The text of Rule 60E abolishes all the common law writs and remedies that were used to get relief. And we would rely, for those who care about this kind of stuff, the advisory committee chairman said there's no way left to get relief other than Rule 60. I mean, you don't have to decide that, and 60D has the one independent action, so they did leave that safety valve. That was very important to the drafters, that there's always an independent action. This court in United States versus Beggarly has said Rule 60D independent actions are reserved to correct gross miscarriages of injustice. So there is that Supreme Court case that says that. And the rule committee note says that laches applies to those kind of actions.
I want to be clear, Ms. Blatt. In this case, we don't have a question, although the Sixth Circuit acknowledged it, about whether the reasonable time period should only start when enforcement is attempted, correct?
Correct. And
right, because that seemed to be a part of your opposing counsel's opening argument, that somehow it was reasonable because...
Yes, and I mean, we think the question presented forecloses that, but we do think that at the time of enforcement, it could be quite reasonable to wait. Here, though,
but you do agree there are many, many judgments entered, some with or without notice, but somebody might find out about something, no one's ever tried to enforce it, and why spend the money getting a lawyer? We don't want to encourage.
Right, that's what I was saying. I think it might quite be reasonable to wait until the time of enforcement. That might be the first time the person's ever heard of it. The person might have reason to think the judgment was never going to be collected. And most importantly, there may be no prejudice from whenever the movement filed. So we would just think a district court would have wide discretion.
Mr. Ginsburg says that almost all the courts of appeals have decided this question against you, and the leading commentators take the opposite position. How do you account for that?
So I think that's correct. I think these courts were writing, either now or at the time in a way that they were comfortable not following the literal text. Some of them acknowledge that they're not following the literal text, and this is just not consistent with the court's modern approach. I will say that most of these courts, at least 5 of them in the dissent, trace back to this D.C. Circuit decision from 1962, Austin versus Smith, that just didn't even mention Rule 60C1. But since, the coming of Justice Scalia in 1986, the court has taken just a different approach to statutory interpretation. And we cite an example of, I think it's U.S. versus Brogan, where all the courts of appeals had ruled 1001 gives you a right to lie, and this court just said, we're going to overrule that. And I think just last term you ruled against a case I argued when all the courts had gone our way.
Well, speaking of last term and lost causes, what do you say about Hewitt and the idea that a judgment that is void ab initio never existed? We can't see it. It doesn't exist. It doesn't exist.
Yeah.
So doesn't that lead to the conclusion that was drawn by all these courts of appeals?
No, and here's why. In addition to it's conflating the grounds for relief in 60B, fraud by the opposing party, and you've already paid the judgment, you've already paid it. How can you make me pay it twice? And the example we give in the brief, and I think it's quite instructive, is the area of preclusion. This court has already said that courts can give effect to void judgments, even concededly void, because if a party unsuccessfully challenges subject matter jurisdiction, they're barred by res judicata and collateral estoppel. And if it's concededly, on its face, it's issued by the Court of Clowns, you have to give effect to the judgment based on res judicata. Now, I will say, if you have a Court of Clowns example, you could probably get rid of that under the independent action for gross injustice.
So your concept of reasonable time, it seems to me, carries with it some idea or consideration of the prejudice to the other side. Is that right?
Well, prejudice to the judgment creditor, and I just think you could reasonably take into account the burden on what Justice Sotomayor was saying about, did the person lack resources? I think that's certainly...
And notice.
Oh, yeah. So definitely, we think due process requires notice. Absolutely. We just think it's due process notice, which is actual or constructive. In other words, you can't hide and go, travel to the moon and avoid notice if the person is, doing all the things that the due process clause requires to give notice. But here, notice is conceded, I think, 6 times over because the trustee kept trying to do it.
Well, suppose somebody who's never left New York City, never traveled west of the Hudson, never done anything on the internet, never bought anything by mail, receives a judgment issued by a state court in Montana, and this person doesn't have a lot of money to hire a lawyer and says, what is this? I've never been in Montana. I don't know anything about this lawsuit. I never was served. I'm just going to ignore it. Wouldn't it be reasonable for that person to have more time to seek relief from this judgment?
Yes, I was trying to concede a lot with Justice Sotomayor, but I don't think Rule 60 applies to state judgments. I think you've got to go to the state court.
No, the rule is very simply, this plaintiff filed in the forum it wanted, and it filed appropriately. It filed against a non-diverse defendant. It was entitled to stay in state court, and it wasn't required to drop a defendant that it didn't want to drop.
It is true that the case did not go the way that the plaintiffs wanted, but that's not enough for prejudice.
Well, yes, because what you're saying is it's prejudice to the court that you're looking at and not prejudice to the party affected.
Not at all. For it to be prejudice to a party, you need to have a material impairment to that party's ability to assert a claim or defend itself.
I think we're going to have to stop there, because I do think suing the people you want to sue in the forum you want to sue them is a material disadvantage.
Do you think, Ms. Harrington, I mean, kind of picking up on Justice Sotomayor's point, it seems it's difficult for me to untangle here the problem of jurisdiction, which I kind of agree with you. I mean, if there wasn't a problem with diversity at the beginning and there was no problem with diversity at the end, and for reasons of efficiency, I mean, Caterpillar would not preclude your position. But there is a sense of unfairness, I think, to the plaintiffs, because they just never get the opportunity to appeal or to try to remedy this wrong unless, I mean, is it just your position they have to try to get an interlocutory appeal at removal and that's it? Otherwise, they just are out of luck?
Well, I think if the dismissed non-diverse defendant were an indispensable party, or somehow the absence of that defendant at the trial affected the outcome of the trial, then you might have an ability on appeal to get the judgment vacated and the whole thing sent back to state court. But here, the absence of Whole Food had literally no effect on the outcome of the trial.
But just to kind of put then a finer point on it, yes, you're saying there just isn't an opportunity to appeal. In the same way, you know, the defendant has a right of removal, but can't appeal a remand.
Right. Well, I mean, this court explained in Caterpillar that the way the rules are structured, it puts a premium on deciding very early in a removed case whether it should be in state court or federal court, and it tolerates some sort of errors, right? If a case is remanded to state court, that decision is never reviewable on appeal, no matter how wrong it was. Ordinarily, a plaintiff has 30 days to object to a removal on non-jurisdictional grounds. And if there's some reason they could have objected and they didn't object in the 30 days, it's too bad it's state.
So it's never reviewable unless there's some sort of prejudice, like a necessary and indispensable party.
Right. So it's not never reviewable, but it's not. You wouldn't correct it if you go all the way to final judgment and there was no jurisdictional problem through that time, unless the absence of that dismissed party somehow affected the outcome of the trial. Yes.
What do we do about the fact that the problem here was created by your client through an improper removal? I mean, in terms of fairness, that your hands aren't exactly clean here, and what do we do about Lexicon, where it was two federal district courts? We weren't even talking about state court. And a judgment was entered, and there was no argument that the judgment in one district court is better than a judgment in another district court, and we completely sent it back to start over because the plaintiff's choice of forum was denied.
Well, it wasn't. I'll start with the second, if that's all right. In Lexicon,
let's start with the first.
Start with the first. Okay. I mean, it's not as if there's no argument that it was a frivolous argument, right? The district court agreed with us. The Fifth Circuit reversed. We accept that.
I'm not saying it was frivolous. Right, I mean, Rule 11, my goodness, I would never accuse you of that.
Thank you, Grant.
However, the plaintiff's choice of forum was effectively denied through an improper removal by your client.
And that's exactly the argument that was made in Caterpillar. And this court said, the plaintiff says, look, if we let this happen, if we take an all's well that ends well approach, in the words of this court.
I get the idea. It's a little bit of a conundrum, but if in fact you're right and that there is a fraudulent joinder, doesn't that just get read back in to the situation that existed at final judgment?
I don't think so. I mean, the Fifth Circuit's decision, with all due respect to them, they don't have a time machine. They can't go back and change.
No, but that's the Caterpillar situation. You would just concede at that point. I mean, you would cure it, right? So fine. Whole Foods was fraudulently joined, and we could continue to go on. But because you win in this situation, you would cure it.
No, but I mean, that would be Newman Green. In Caterpillar, the non-diverse defendant was already out of the case before final judgment was entered.
I understand, but the idea is that some jurisdictional defects can be cured by the time we get to final judgment. And Caterpillar, the cure was the person was actually settled out of the case permanently.
Yes.
And so we don't worry about the fact that previously in the case there might have been a jurisdictional problem. What I'm saying is that same solution would seem to me to be the answer to the conundrum that you're talking about with Justice Kagan.
I disagree, Justice Jackson. I think either a party is in a case or isn't in a case in the district court.
What about the incentives for people like your client who remove and then can't count on the fraudulent joinder dismissal? And then your client, I mean, would you want to remove if you thought you were at risk of investing all the resources in litigating the case to final judgment and then potentially losing it on appeal? I mean, what would it do to the doctor just from a matter of litigation incentives?
I mean, I think it creates strange incentives, but I'm not sure, I think defendants who think they have a right to remove will still remove. We assume good faith by parties. They're not going to assert a fraudulent joinder argument if they don't think it's valid, but it creates opportunity for a great deal of waste and sort of violence to principles of finality and economy, because nothing that happened in this case after the initial dismissal of Whole Foods involved any non-diverse party. There was 2 years of litigation, there was a trial, there was final judgment on the merits. All of that was among completely diverse parties. Whole Foods never got in the door. And so there's no reason to go back and say, well, we're just going to get rid of all of that and have a do-over, because the absence of Whole Foods didn't have any effect on the outcome. It didn't have any effect on what happened at trial. The plaintiffs could have sought third-party discovery against Whole Foods. They didn't. Whole Foods was barely even mentioned in the trial.
But can we go back to Justice Sotomayor's point about prejudice? So is it your view that there would be no potentially preclusive effect of this judgment on a subsequent determination or a subsequent trial related to Whole Foods? I mean, is your client not going to argue that Hain should lose that as well?
I mean, if that Hain should lose, I mean,
or that Whole Foods should lose.
So I think
Whole Foods, I mean,
right,
I sense a potential prejudice from having to try this twice, when initially the plaintiff here wanted to bring one lawsuit against both of these defendants. And so I guess I'm asking, if we say it's okay to affirm the judgment with respect to this one defendant and it's fine because the plaintiff can go on to sue Whole Foods, is there any possibility of some kind of preclusion in the Whole Foods lawsuit?
So that's a question for state law that would need to be decided by the state court, I think. But even if the state court did say, yes, this determination that was made at the district court has preclusive effect with respect to the claims against Whole Foods, that wouldn't be prejudice.
If it's turning on prejudice, I mean, the court, normally we don't think of whether the court had jurisdiction or not as dependent on whether there's prejudice to a party.
Right, I'm talking, right, that's it. The question is, like, what is the remedy for the fact that you should have been able to have these two defendants together, right? The automatic remedy when you should have been able to sue two defendants together, one was improperly dismissed, and you didn't, is not automatically to vacate the judgment for the other defendant. You would only do that if the absence of the dismissed defendant affected the outcome, affected that judgment. But where it didn't, there's no reason to vacate that.
I mean, it is a pretty awkward rule to say that a jurisdictional defect, the remedy for it depends upon prejudice in a particular showing. And again, we didn't do that in lexicon.
Well, I'll try one more time. There's no jurisdictional defect here once you get rid of the dismissed defendant.
I understand your point.
Right. And so the question is, if the error was separating these claims against the two different defendants, what is the remedy for that error? That's really what the error was here.
But you're treating it as, we separated two defendants improperly. But in fact, from the plaintiff's point of view, what the thing that went wrong is that the plaintiff is the master of her complaint. She clearly structured a suit in order to bring it in state court. That was why she joined these two parties, perfectly legitimately, in order to have the suit in state court rather than in federal court where it was. And the effect of this district court misjudgment was not that two parties were separated, is that the suit was tried in the wrong place from the plaintiff's point of view. And the plaintiff's point of view is the thing that should matter, because the plaintiff is the master of her complaint.
So I'll say a couple of things. It is true that the plaintiff is the master of her complaint, but that isn't a jurisdictional principle. That's sort of an overarching principle that guides federal.
This would be a lot cleaner case if you had appealed the dismissal. Why didn't you?
Your Honor,
because the court held in Caterpillar that there's no obligation to seek immediate review to preserve the right to an ultimate appeal on this issue. This is no different than any other threshold jurisdictional issue that arises and is preserved. This most frequently arises when a defendant wants to preserve an objection, for example, to Article III jurisdiction based on a standing objection. Those types of issues are frequently preserved early in litigation and are not ultimately vindicated until the end of the appeal for a final judgment. That's sort of inherent in the doctrine that appellate review is ordinarily deferred until after final judgment under this court's merger rule. Elected not to do so.
But you could, too, and your position was that you were standing on Caterpillar. I mean, Caterpillar does not answer this question, clearly one way or another. So, I mean, that makes it seem like your choice was to take a wait-and-see approach and then decide whether you liked the result or not before you chose to fight it.
That's not correct, Your Honor. I do want to confirm the principal point that the court made. Caterpillar does not resolve this question, as the petitioners acknowledge in their reply brief, because it recognizes that if the jurisdictional defect remains uncured at final judgment, vacature is required.
What is your answer to the questions about preclusion that Justice Jackson was asking you earlier? What would happen in state court? Do you think you would be, barred by non-mutual issue preclusion from relitigating some of these issues?
That is a controversial question. We certainly would not concede that preclusion would lie here. I would argue that there may be exceptions under state law, both because of the nature of the jurisdictional ruling in the first instance and because there could be differences in sufficiency evaluation under state law as opposed to federal law. But all of that presupposes that the jurisdictional problem could be cured and that judgment could actually have any substance on the merits, which I think is incorrect. I do want to speak directly to the court's question. The reason that there was not an immediate appeal taken was not only that the plaintiffs were relying on their right to seek review after final judgment, but as a practical matter in litigation, litigants make their best arguments, they preserve their positions, they respect the rulings, and they move forward. And our clients moved forward to litigate the case on the merits as best they could with respect for the district court's ruling.
What about prejudice, though? One of the reasons why I brought up preclusion was because there was an argument that given that Whole Foods was not actually part of this litigation, that you are not prejudiced by having to sue them in state court separately.
Well, Your Honor, of course, prejudice is not a material consideration where we're dealing with the first principles of limited federal jurisdiction. And so I think principally the plaintiffs do not have to demonstrate prejudice to satisfy the court that there's a lack of jurisdiction in this instance. But it certainly is the case that the plaintiff, as the court has indicated, is the master of the complaint. And that is a jurisdictional principle, contrary to what counsel said. The right of the plaintiff to configure the case for purposes of litigation is a function of the congressional scheme that makes jurisdiction turn on the claims and the parties.
I don't think you're answering Justice Jackson's question, though. I have the same one, right? Aren't you asking whether the judgment was, how did it hurt your client that Whole Foods wasn't in the case when, your friend on the other side is pointing out that nothing in the case turned on Whole Foods or its evidence? Put aside the jurisdictional point for now.
And I appreciate the point. My point was simply to be that the lack of the state forum in a single proceeding in which both defendants could be brought within the same proceeding is itself prejudicial.
So I take it it's a very abstract prejudice in the same way that your friend on the other side said it's abstract. It didn't really affect the outcome. You're not saying the outcome would have been different. You can't point to anything like that.
That's the jurisdictional principle. That's right, Your Honor. With respect to practical prejudice, as a practical matter, the way this case was litigated with Whole Foods out of the case, there was no opportunity for the plaintiffs to develop the evidence that they would have developed about the role of Whole Foods in actually making express misrepresentations about the quality of the baby food at issue. And so it is true that as the case was tried, it was tried solely based on the quality of the product. But that was an artifact of the erroneous ruling, an erroneous eerie guess made by the district court about the content of state law that should have been a determination made by the state courts consistent with the congressional scheme.
I'm sorry, you lost on causation, meaning I thought you lost on first principle, which is that even if there was toxic substances, they didn't cause this condition.
Your Honor, there's a dispute about the accuracy of that ruling. That's correct. The district court found that there was a failure of proof of causation.
Well, you lost that on appeal, so it's gone.
We did not, Your Honor. That question was never decided by the Fifth Circuit. It would remain to be decided.
How would you get to the authority under the spending clause to create these damages actions that you suggest?
So I think there's sort of two paths.
In this case?
In this case, I think there's two paths to do it. One is to follow the path that this Court has set forth in Salinas, in particular, Salinas, Dixon, Laudani, and Hess, and to just hold that.
What was Salinas about?
Salinas was about an officer in a federally funded state prison who accepted a bribe to provide preferential treatment.
Isn't there a difference between a bribe and a lawsuit for individual damages?
Well, he was being held individually liable for criminal penalties, which I think is something that clearly requires the necessary and proper clause in addition to just ordinary
civil. I thought the argument there was that if you provide the funds, you have a right to protect it.
I think that protection of funds, well, maybe sort of two things. First, in Salinas, when the Court was describing the thing that was interfering with the proper operation of the program, it wasn't the acceptance of the bribe. It was the preferential conjugal visits. It was the misconduct itself. And so just applying the test that Salinas set forth, and I think actually my friends don't.
Make that clear, there were no federal funds at issue. The bribe was going into a correction officer's pocket, correct?
That's right. There was no
so no
diversion
risk to
of
the
federal
government's
funds.
money.
Pardon?
No risk to the government's money.
That's at least certainly not direct. If anything, it was prophylactic. And here I think it's really much more direct.
Slow down, counsel.
Sorry.
The question there then was the risk to the government program, correct?
Correct.
And here the risk is to what?
To the government program to accommodate religious liberty. I mean, that's the heart of this program under RLUIPA is if you want federal funds for state prisons, you need to accommodate religious liberty.
Now, going back to Justice Thomas's question about other statutes that are at risk, if we were to hold that you can't bind third parties, I have dozens of them cited by you and the government where we've permitted or causes of action with damages, Title IX, Title VI, the Federal Nursing Home Reform Act, the Emergency Medical Treatment Act, the anti-fraud statutes. There's a long list of statutes where we said the statutes can bind third parties, correct?
Correct.
All right. Thank you.
Counsel, the basis for state liability here is, of course, an agreement with the federal government, right? In other words, they've cut a deal, get the money, and they're going to have to comply with these conditions. But there was no such arrangement with the defendant in this case, right? They didn't have a direct relationship with the federal government. They didn't get directly any federal financial assistance. So you don't have the same basis for liability as we do in the other typical spending clause case, right?
Right. It's indirect, right? Because the officer, and what this Court said in Rust is that if a person goes to work for a federally funded program, then they take the job subject to the conditions that Congress has attached to the funds. And, of course, I think they're already admitting, again, that they're bound by the substantive condition, really by virtue of their choice to voluntarily work as officers in a federally funded program. And so I think it's that sort of the chain of privity is the thing that makes this case sort of considerably easier, I think, than a case like Sabri or some others where you're trying to reach somebody who's a member of the general public. Because these are not members of the general public. They're state officers. They voluntarily accepted this job. They each have all of their own employment contracts, and they take it subject to that condition.
But the hard part, as I see it for your case, for me, is that you need a clear statement and appropriate relief. It's not as clear as it could be in encompassing damages. So how do you deal with that? I don't want to water down our precedent on that. But at the same time, I want to hear your response to how you get there.
Yeah, I think it's sort of the first thing, and I'd love for you to look at it, is just to lay eyes on the individual capacity action. It's in the Pet app at 41A. It's got a cause of action. It's titled Judicial Relief is the name of the statute, and then subsection A, cause of action. A person may assert a violation of this chapter as a claim or defense in a judicial proceeding to obtain appropriate relief against the government, who is the government. You go in a few pages, and it says an official or any other person acting under color of state law. And that's just obviously individual capacity. Tanzan already says that. It says that it provides a clear answer, and the text is identical. And then I think once you see there's...
On Tanzan, I'm not sure it quite says clear answer. I think it says it's the best answer. It's a traditional answer. I'm not sure it quite says...
On that point, and then I want to get back to the Chief Justice's question. As I understand it, the circuits are unanimously against you and have been for many, many, many years. So saying that something awful is going to happen, whatever's happened has happened, right?
That's correct. It's happening. Yeah.
Yeah, and it's been this way for a very long time in every circuit in the country.
That's correct.
Yeah. And on the Chief Justice's question, I'm struggling. Where I'm struggling is where did the defendant, the individual defendants, agree with the federal government to be bound, and what notice did they have? And I understand your point earlier to the Chief that they're subject to state regulations and with their contract with the state. And, of course, an agent can be liable to his principal for violating what the principal dictates. But the agent isn't normally liable to a third party for a breach of the principal's duties with respect to a third party. So even when the agent causes the breach, even when the agent negotiates the contract, he's not liable to the third party. He's only liable to the principal. So if we're looking to background contract principles, to the extent they're relevant, and maybe you're going to tell me they're not, that's fine, but to the extent we would, it wouldn't seem to encompass these defendants, and every circuit court in the country would appear to be correct.
So
help me with that.
Yeah, I think what that's missing, we trace this out in our opening brief, is that contracts are extraordinarily flexible, and you can, and people do.
Yes. Okay. Your brief does go into that Congress could have easily written a statute that does this and says that those individual officers have to agree with the federal government to be bound under federal law. I agree. It could have done that. And you say it could have done this in 15 different ways in your brief. I agree with you. My concern is it didn't do that. It could do that, but it didn't do that. It left it to the states.
I think that's really where I fundamentally disagree.
Okay.
I think Congress did do it. What it said in this statute is that, first of all, obviously the states need to accommodate religious liberty, and then it is clear as day that if you agree to be an officer or other person acting under color of state law in this statute, and you deprive a person of their religious liberties in violation of this statute, then you are subject to suit where you will be the defendant in a cause of action for appropriate relief. That is on the face of the statute. And the individual officers, they can agree to take the job or not. They can demand higher wages. They can demand indemnity like Louisiana gives it. And I think one of the things that really breaks down in their argument is they admit that it applies to them. They admit that they need to comply within the scope of their work.
Would you agree that the individual defendants have to have notice?
I think as the way this Court's precedents work, the notice runs to the state, and then as defendants...
So the defendants don't have to have notice?
Why don't they have notice?
If I might just finish, I'm sorry. Do the defendants have to have notice?
If I could be
yes
clear,
or no?
If I could be clear, it depends on which way you think about it. One way to think about it runs all the way through consent. And then, of course, they need notice because they took the job. They have to take it subject to the conditions.
Counsel, it's just really simple. Do the individual defendants have to have notice?
They have to have notice of the condition when they sign up to it.
And do they have to consent to the conditions?
I mean, they consent by virtue of taking the job. Yes.
Do they have to consent?
By taking the job, yes.
Is that a yes, they have to consent, or is that no, they don't?
I mean, under this Court's sorry, I just want to be clear about this.
I just want to know what your answer is.
My answer is that they did consent here, that if you're going to think about this purely as a matter of consent, which we trace through in our opening brief, then, of course, they need to consent.
Your answer that you've just given to my colleague is based on a legal fiction, right? If you're hired as a prison guard in Louisiana, you don't sit down, and I don't even know if Louisiana does, saying, oh, here's our agreement with the federal government, which probably goes on for I don't know how many pages, and you should look at it carefully because you're bound by it. That's not what happens as a matter of practice, and I don't think when the prison guard is hired, he says, well, I want to see the federal conditions that you agreed to under the contract.
I mean, I certainly doubt that anything like that happens, but we do have the amicus brief of the former corrections officials that talks about how there is training on compliance with federal law, that individual capacity damages are the norm. And again, they're not disputing that they need to comply with RLUIPA's substantive condition in the scope of their work. And I think what they haven't come up with is any kind of reasoned explanation why Congress can impose the condition on them, but then can't enforce it, especially through civil liability, when this court in Salinas, Dixon, Hess, and Laudani has already done that and actually gone farther. And I think Sabry goes considerably farther.
Thank you, counsel. Justice Thomas?
Are we to analyze this any differently under the spending clause than we would under one of the enumerated powers?
I think that the spending clause, of course, impacts the analysis. I think it impacts the textual.
How does it impact?
Well, I think from this court's cases and like Dole, among other things, that there needs to be clear notice, which is why I started there, and I think it's been fully provided.
Do we throw out in that analysis the contract analogy or framework?
I think the contract analogy is a helpful framework, I think, for understanding the scope of the spending clause alone. But this court has made clear, and respondents are not asking you to overrule any of your precedents. This court has made clear repeatedly that Congress can also combine spending with necessary and proper. And I think one of the things that's unusual about this case is that this is within Congress's power either way you look at it, because of the chain of privity gets you there on consent, and then Salinas gets you with necessary and proper. I mean, Salinas is criminal liability, which is never available via contract, whereas this is just civil. This is an ordinary remedy available as a matter of contract. I think this is really much more in the heartland of Congress's power.
I just don't see how you could say no, given the assumptions he asked you to make about the spending clause.
But I want to be clear. One of the reasons I've been articulating this rule under Salinas, right, which is these 4 ingredients, valid condition, officer within the scope, and threatening the program, is it doesn't require you to address, I think, some of these. There are hard hypotheticals about.
Well, Mr. Tripp, every time we decide a case, we have to think about what it's, in Salinas and Sabry, if they had looked ahead to this case, might have said, yeah, this might be where the logic leads, or you take a few steps from here and this is where it goes. But we can't decide a case just based on these facts. So you just need to own it.
I want to be clear about that. But what I'm saying, and the reason why, especially in our reply brief, we're relying heavily on Salinas, is you've already said all of this. And so we're not asking the court to break new ground.
Well, I think the necessary and proper clause may mean other things, even if you're right. But so in light of what you said, your answer to Justice Barrett's questions is yes, right? They can be held liable whether they know, whether they don't know, quite across the board.
For government officials, yes. As to the hypos, I think that one of Justice Gorsuch's hypos, which Justice Barrett followed, might have included private parties. The government doesn't take a position as to how this would cash out in terms of private parties. I think, as Petitioner's Counsel noted, I think there's obviously different issues of consent, especially when we're talking about reaching a member of the general public. But in terms of reaching government employees and agents, we think that they can clearly be reached.
Whoa. Let's back up. We're talking about a spending power statute, okay? And everybody has to agree, I think, that consent and notice are required for a state to be bound, right?
Yes.
And are you saying those are or are not required for the state employee to be bound?
So under the spending clause, I think that the sort of privity argument that we've been talking about today.
So no is the answer, because it works for the state, and because the state employs these individuals, they're necessarily bound.
I do think that's right, and I think that's...
So no consent and no notice is required for the employee. That has to be the logic of your view.
I think not as a formal matter in terms of under the spending clause, but I think the reason that this is such an easy case under either the spending...
No, Ms. Baird, so it sounds to me like you want to use the contract analogy to limit the scope of this argument, because you keep saying, well, no, this is privity, and that's why we don't need to take a position on whether it would reach a member of the general public, right? But then you're moving away from the contract analogy when Justice Gorsuch is asking you about, well, do these principles of contract law apply? I don't understand. It seems like we're slipping in and out of the contract analogy.
Yeah, so let me try to be clear, Justice Barrett. I think that the contract analogy applies to determine whether there's notice. I think this Court's cases are clear that the notice that matters is the state's notice. I do think that the officers can be fairly held to account for notice here.
Well, would the Dole factors be met in that situation?
Well, I don't want to take a position on sort of the outer reaches of the spending clause because this case is really about enforcement. And so I don't want to get ahead of the United States on very difficult questions about how far does the spending clause go. I think the important thing is that there are limits. The dole factors, there's the unconstitutional conditions doctrine. Congress can't condition funds on someone giving up their constitutional rights. There's coercion. And then I think the remedy itself has to be constitutional. It has to comply with due process. And then as I was talking with Justice Barrett about it, also has to be necessary and proper. So there may be some instances in which a remedy is not necessary to enforce a condition or a proper means of enforcing the condition, and those requirements can have teeth.
Well, you're asking us to take an important step. It would be helpful if we had an idea about where this road is leading, but you don't want to provide an answer to that.
Well, Justice Alito, I think because it's not presented in this case. I think that when the court has a spending clause case about how far Congress can go in imposing the condition, then I'm sure we'll be up here as a party talking about that with you.
But the actual dollars and cents weren't at issue in that case. What the court was upholding was the federal government's right to say we shouldn't, we need some strings in place to ensure that the money we pay to a federal institution is going to an honest federal institution, an institution that won't be profligate with our money generally, even though there's no nexus with the money here. And so, too, the government can say, the integrity of the institution has something to do with not taking bribes, and the integrity of the institution has something to do with not violating rights. And both of those things fall within the federal government's interests.
And respectfully, Justice Kagan, that's not consistent with Sabri. Look at page 606. This is the money is fungible paragraph that spans 605 to 606. The theory that the court was articulating there to sustain statutes like 666 is to say, what is the articulated federal interest in the statute? And the very last sentence of that paragraph says the federal interest here are federal dollar thresholds that Congress embedded in the statute as its putative protection. Now, I'll grant you, Justice Kagan, that Sabri, I think, has to be the outer limit of the Congress's necessary and proper clause authority because what it was doing there really had no direct tie to the funds at all. But the theory that this court cited in justifying reaching the result it did was to say we're going to look at the federal dollar thresholds in 666. We're going to say, well, Congress is at least pretending to protect those federal dollars.
I'm sorry, but it's the same thing here, meaning they're trying to protect their federal dollars from not supporting a program that violates religious liberty. So I'm not sure that distinction makes any sense to me.
Your Honor, that's not correct because there's a very important difference between Congress protecting its constitutional authority to spend and its constitutional
And it has constitutional authority to spend and give money to state prisons as well.
But
it wasn't in those programs. It could spend on programs, but it didn't have to.
But what Congress does not have inherent sovereign authority to do under the spending clause is regulate. The only way it can regulate is if the recipient of the federal funds agrees in return.
But a criminal statute is regulation.
It absolutely is regulation, Your Honor. But what I'm saying, what this court said in Sabri is that a statute like 666 is not spending. That's not a spending condition at all. And that's why I think the most important starting point in this court's analysis is to ask, is this a spending condition? The federal government agrees at page 23.
If we disagree with that.
And I'm happy to take the disagreement, Justice Sotomayor, but I do think that line that this court drew at the end of Section 2 in Sabri is the right way to think about this. And
I mean, the surprise that you were saying employees would have, are they surprised to learn that they find themselves subjected to 1983 suits all the time?
Well, Justice Kagan, Section 1983 is a remedy, right? It's a cause of action that gives a remedy. And your earlier question about can't you just do this all under 1983?
I didn't say can't you do. What I'm saying is that your arguments that they're not getting notice, that there's not enough knowledge, I mean, that would just make 1983 suits. The same objections could be held with respect to that. And yet 1983 exists. People bring 1983 suits against state officers all the time, including to enforce statutes that have been enacted pursuant to the spending clause.
That's right, Justice Kagan. And remember that when we're talking about 1983, the antecedent question, at least in the spending clause context, is whether the asserted right under the spending clause legislation is one that can be enforced in 1983. And I think the important point there in that antecedent question is the question we're dealing with in our red brief is, can Congress use the spending clause to create a substantive right that runs against a state official in his personal capacity? And if the answer to that is no, then you never get to Section 1980.
Didn't we answer that question in Tlefsky? I thought we said in the 1983 context that it didn't matter that it was spending clause legislation. We said a law is a law.
We said secured by the laws of the United States include secured by laws enacted pursuant to the spending clause.
That's right. And the question in this case is, does Congress have constitutional authority under its spending clause power to do what petitioners say it did?
No, but I'm saying, why are you not undoing that Tlefsky holding with the argument that you're making today?
Your Honor, because cases like Tlefsky are dealing with suits that are actually against recipients, funding recipients, right? I mean, that's nobody disputes that in the—
That's just the distinction you're bringing in. What I think Justice Kagan was getting at is there's something about your argument that turns on this being spending clause legislation, and that has something to do with the extent to which it can be enforced in this way. And we said in the context of 1983 that it didn't matter that it was spending clause legislation, and what she, I think, is trying to say is, why should it matter here? And if it does matter here, doesn't that imperil the determination that we made in Tlefsky that spending clause legislation should be treated just like any other law for this purpose?
Your Honor, it matters here because of cases like Cummings that trace all the way back to Pennhurst that say the very legitimacy of Congress's exercise of spending clause authority depends on that bilateral agreement. Is it sending money out and taking a reciprocal promise to comply with conditions in? If you're missing that reciprocal consent from a recipient or putative non—
Do you think the term compassionate release suggests the circumstances that you have in this case?
Your Honor, the term compassionate release is a term that has been used colloquially and was used at one point in a Department of Justice regulation. We certainly concede that that term does seem to relate to personal circumstances, but it doesn't necessarily foreclose the possibility that courts would consider other issues related to the fairness of the defendant's sentence.
During the years that the Bureau of Prisons actually initiated this process, were there any circumstances in which a trial error would be the basis of the motion?
Certainly, there were very few cases, period, when the BOP was involved.
But even in the few cases, were there any of this nature?
There were not, Your Honor.
What was the nature of those?
Those were generally where a prisoner was terminally ill or old. And
in other words, personal circumstances.
They were certainly personal circumstances. But we also saw, as our amicus fam on page 15 of their brief, they cite the Diaco case, which relates to the predecessor, 4205G, where there were cases related. There was one case relating to sentencing disparities, and that was one of the only two cases that are published about the use of 4205.
Well, you just mentioned mandatory minimum sentences. There are a lot of district judges and other federal judges who don't like mandatory minimums. So if a prisoner has been sentenced to a mandatory minimum sentence, could a district judge say, if a motion under 3582 is made, you know what, that mandatory minimum is too much under the circumstances of this case, so I'm going to grant a sentence reduction?
Well, Your Honor, Section 3582 does allow sentencing under 3582 under the mandatory minimum for any extraordinary and compelling reason. But certainly it's our position that a court could not just say, I don't like mandatory minimums, and therefore I won't apply them. It has to be something about the unfairness of that mandatory minimum in a particular case.
Would you agree that one of the principal goals or a major goal of the Sentencing Reform Act was fidelity? The Sentencing Reform Act got rid of parole. It didn't like the situation where someone would be sentenced to 30 years in prison. This was standard at the time. Maximum a life sentence was considered to be 30 years, but then after 10 years, the person would be paroled. It got rid of all that. Would you agree that that was a major goal of the a major objective of the Sentencing Reform Act?
Absolutely, Your Honor, but it was also a goal in 3582 to have a safety valve where judges could still exercise discretion at a later point in the process.
I mean, just to continue in that vein, do you think that the district court here on the initial trial could have received the jury's verdict of guilt and said, I'm not going to overturn that verdict of guilt. I have no basis for doing that. But in the sentencing, I'm going to reduce the sentence because I feel disquiet with respect to that verdict. Could the district court have done that?
Well, certainly not in this case, Your Honor, because it was a mandatory life sentence. But as a general matter, while the court does have to take the verdict as given when conducting the guidelines analysis and the 3553 analysis, how the court weighs the different factors such as personal circumstances, the nature and the characteristics and history of the defendant, it can certainly weigh those factors.
Well, personal circumstances, you broadened it out. I really was limiting it to would it be appropriate for a district court to say, I'm not overturning the jury verdict, but I'm not sure I agree with it. Therefore, I'm going to reduce the sentence below what I would ordinarily give.
I think in weighing the 3553 factors, as long as the court recognizes that the verdict was guilty and takes that into consideration, how it weighs the verdict and the offense with the personal circumstances could be taken into account and can result in a lower sentence.
I mean, just to continue in that vein, do you think that the district court here on the initial trial could have received the jury's verdict of guilt and said, I'm not going to overturn that verdict of guilt. I have no basis for doing that. But in the sentencing, I'm going to reduce the sentence because I feel disquiet with respect to that verdict. Could the district court have done that?
Well, certainly not in this case, Your Honor, because it was a mandatory life sentence. But as a general matter, while the court does have to take the verdict as given when conducting the guidelines analysis and the 3553 analysis, how the court weighs the different factors such as personal circumstances, the nature and the characteristics and history of the defendant, it can certainly weigh those factors.
Well, personal circumstances, you broadened it out. I really was limiting it to would it be appropriate for a district court to say, I'm not overturning the jury verdict, but I'm not sure I agree with it. Therefore, I'm going to reduce the sentence below what I would ordinarily give.
I think in weighing the 3553 factors, as long as the court recognizes that the verdict was guilty and takes that into consideration, how it weighs the verdict and the offense with the personal circumstances could be taken into account and can result in a lower sentence.
Thank you.
Mrs. Gorsuch?
I'm not sure I understood that last answer. I don't doubt 3553A factors are very broad and give the district judge rightly lots of discretion in sentencing when there's not a mandatory minimum. But I wouldn't have thought that one of the circumstances, personal circumstances that a judge could take into account has, as Justice Sotomayor says, really nothing to do with the defendant. It has to do with the judge's own disquiet, perhaps reasonably so, about the jury's verdict. And I had thought in our legal system the jury's verdict on the facts is not something a court can impeach unless it's clearly erroneous.
That's correct, Your Honor. And what I was referring to in answering Justice Kagan is that the judge here, for example, referenced the fact that the defendant had no history of violence,
Sure.
that he was a working man.
All of that's fair game. I agree with you. I'm not, again, I don't question any of that. But the appropriate remedy for disquiet about a jury verdict is to set it aside as beyond the pale. It isn't to say I disagree with the jury about the facts and therefore I'm reducing the sentence, is it?
Well, normally it isn't, but under 3582.
No, I understand your 3582 argument, but under 3553, that's not an appropriate consideration, is it?
It could be a consideration when weighing all the factors, deciding how much weight to give to questions like protecting the public from the defendant or the...
I think in that, protecting the defendant from the public, you have to take as given, again, the jury verdict. I don't think you get to impeach it by saying I just disagree with it.
Right, but I agree with that, Your Honor,
okay.
But the question is how to weigh it.
Just one more on the role of the commission. Do you think the commission could, under 994T, say that claims of error in the conviction or sentence are not cognizable, are not extraordinary and compelling circumstances for purposes of these motions?
Yes, Your Honor. The Commission has the discretion to decide what is within the meaning of the words and to take the position that certain things are off the table, yes.
And you think if they said that as to this issue, that would be that you wouldn't be able to challenge that?
That's correct, Your Honor. District courts would have to comply with that guidance.
So where's the personal circumstances limit that the government is relying on here?
So I think there's a lot of reasons to think that, Your Honor. There's a lot packed into that question, or a few parts packed into that question. But first of all, I think the very language, extraordinary and compelling circumstances that warrant a sentence reduction, requires a court to look at the backdrop of sentencing law. It's not extraordinary and compelling in a vacuum. It's extraordinary and compelling reasons that warrant a sentence reduction. Second, I think there's a category mismatch when we're talking about these kinds of legal claims here, because as has been noted this morning, when you raise a Section 2255 claim, you're challenging the validity of the criminal judgment. And Section 3582C1A1, we talk about this in our brief, presumes that the judgment is valid, and it's about reducing a valid sentence. And there's kind of a category mismatch with taking a reason why the sentence is invalid.
But why doesn't that cut against you? That was the point I was trying to make to your colleague on the other side, which is that to the extent these are two different things and that compassionate release assumes a valid sentence and that you need to have it, or you're asking for a sentence reduction notwithstanding that, why then are we evaluating your ability to get one of those vis-a-vis what you could do in the other world where you'd be claiming that your sentence or conviction is invalid?
I think it cuts entirely in our favor, Your Honor, because it shows that these are meant for personal circumstances, because it doesn't really make any logical sense to reduce a valid sentence because of a procedurally or substantively deficient claim. The point of the claim being that the sentence was actually invalid. That is, you're taking, to use a slightly pejorative term, a kind of half-baked claim of legal error in a conviction or sentence and saying, okay, yeah, it's not quite there, but that's a reason for taking the sentence as a given and reducing it. I don't think that makes sense, and that points again toward personal circumstances.
I mean, there might be changed circumstances that are not personal in nature, that are in fact legal in nature, and so that there would be a divide between your personal circumstances line and the changed circumstances line. And the example I'll give you is, suppose the statutory construction, the way the courts interpret a given statute, have changed since the initial sentencing, such that somebody was sentenced to, let's say, a long sentence, and then the courts say no. If he were coming up today, actually he wouldn't be found guilty at all. What do you do with that? Is that the kind of thing that can be taken into account under this statute?
No, Your Honor. It's not the kind of thing that can be taken into account, because that's something that's otherwise addressed in the legal system. And the Court had a case about this a few years ago. It was Jones against Hendricks.
My question is, could the Commission, under its broad authority, under 994T, do the same thing or not? And if not, why not?
No, we don't think that the Commission, in a post-Loper Bright world, has the authority to make something that's not an extraordinary and compelling reason that warrants a sentence reduction into something that is an extraordinary and compelling reason that warrants a sentence reduction.
I don't know how Loper Bright affects that, but extraordinary and compelling are both capacious terms that leave a lot of discretion, aren't they?
Let me give you a longer answer to this, Your Honor, which goes probably a little bit more to the next case. But first of all, it's just a pure question of statutory interpretation. If these words don't cover it, then the Commission can't add them. Second, the Commission is required to comply with all provisions of law under 994A, and they acknowledge that. They actually accept something from their new Rule B6 because it's covered by 3582C2, and they don't think they can expand on that. But even beyond that, Your Honor, the commission doesn't have just general authority to override general provisions of sentencing law, because the commission isn't the exclusive interpreter of extraordinary and compelling circumstance.
You win if Justice Thomas's point, though, doesn't make the commission's judgment inconsistent with the statute. Now, you have an answer to that, but there's an if, I think, that goes after what you just said.
And I'm happy to provide that answer, which is that Congress didn't intend to take the commission's discretion away when it never addressed the issue of how compassionate release motions should be treated in this gun situation when they're taking the stacking away. And it certainly has a profound effect on the one issue we know Congress wanted in compassionate release cases to be considered, length of sentence. The whole idea of compassion, obviously, is to bring compassion by lowering the amount of time that a person is incarcerated.
Is it the plus factors that then would prevent it from becoming a huge loophole?
Justice Barrett, these are always combination of factors. No one factor, I think, arises to the level that it would by itself be extraordinary and compelling, because the word reasons is in the statute. So it's got to be multiple reasons. Our client, of course, as you noted, had a very good rehabilitation record, has health issues, has family circumstances where if his earlier release would enable him to help find and provide for his deceased sister's children. So these are the kinds of circumstances that a judge reasonably would take into account.
Could a judge, let's say before the First Step Act was enacted, say that in my judgment, I really feel like these are excessively long sentences, and treat that, like the judges, let's just say it's disquiet about the legal penalty that Congress has chosen to impose. Would that be an extraordinary and compelling reason, or is it only the subsequent change?
Length of sentence is a factor, and it always has been a factor. And we know that because the Diaco case, the Bureau of Prisons, represented by the Department of Justice, came to court and said the long sentence should be reduced because of these disparate circumstances.
Well, no. I'm just saying, just based on the judge's disagreement, the judge's disagreement with the length of sentence that Congress chose to impose as a mandatory minimum.
Mandatory minimums have long been thought to fall within the rule of compassionate release. So has life imprisonment, for that matter. And the Department of Justice agrees with that observation, filed a brief a couple of months ago in the Sixth Circuit in a case called Stricker, in which it took that position. So that is not an unusual feature of how compassionate release works, and that makes sense.
Mr. Friedrich, I'm hearing Justice Barrett's question differently, and she'll correct me if I'm wrong. I think her question is, standing alone, could a judge use their unhappiness with mandatory minimums to grant compassionate release?
That would be, I think, an abuse of discretion, because the mandatory minimums set forth by statute indicates what Congress's judgment is. The extraordinary and compelling reasons are almost always plural, and in fact, the form that—
But even if it weren't plural, could the judge take disquiet or disagreement with the statutory scheme prescribed by the statute as one of the reasons?
Certainly the judge, in looking at the range of factors, would take into account that person's experience in looking at like cases to determine whether there was—
I'm not sure I understood your answer to Justice Barrett. Is it a permissible factor for a judge to include in the determination disapproval of the mandatory minimum?
A judge would be committing an abuse of discretion to disagree with a policy judgment made by Congress. However, a judge would also be within his or her discretion to say that for this particular inmate, given the circumstances here, this minimum would be subject to compassionate release.
I don't quite see the difference between those two things.
Well, the difference, Your Honor, is that we're looking at the totality of the circumstances, the person's age, how much time the person served, whether the person has health issues and the range of rehabilitation and other family circumstances. And the court could very well say, this mandatory minimum is too harsh, and because of all these other factors.
So the answer is that it can be considered, disapproval of mandatory minimums across the board can be considered in a particular case if there is something else.
I think that the part of where I'm going to challenge your question's premise a little bit, Justice Alito, if I might, is that where you say in all circumstances, because the judge is always looking at the one case.
Well, just to continue the line of questioning briefly, well, you really shouldn't call it a mandatory minimum then. You probably should call it something like the presumptive minimum, depending upon subsequent developments.
Well, it's not for me to offer up words to Congress that Congress wrote in its statutes, Mr. Chief Justice. What I would say that as a practical matter, compassionate release is the rare circumstance where, as a safety valve, the court takes into account the total mix of information in determining whether a downward adjustment in the length of time that the person incarcerated should serve.
Well, in second-guessing the judgment of Congress.
Well, Congress also has delegated this authority to the Sentencing Commission, and the Sentencing Commission has issued policy statements that speak to this very question that's at issue in our case, and district courts have exercised their discretion in compassionate release cases to deal with the mandatory minimum concept.
When you said middle ground earlier, you were really focusing, I think, on the 10-year point. Is that accurate?
It's not just the 10-year point. When the Commission first took this issue, it was urged to adopt a provision that would have said whenever changes are inequitable in light of changes of the law, that would have allowed it. It didn't adopt that provision.
Do you think they could have adopted that?
I think that probably would have been within the scope of the Commission's discretion. But I'd like to make 2 points about the government's parade of horribles here. The first is there's nothing in the Commission's history or its composition that would suggest it's going to adopt anything like the kinds of proposals that the government fears. In fact, the Commission's history is that it has been quite cautious, not cavalier, about the use of this power. If it did adopt any of those outlandish proposals, the guidance has to go in front of Congress for 6 months before it goes into effect, and Congress could reject it during that time, as Congress has done with previous Commission guidance. And then the second point is the fact that the Commission could have gone farther but chose not to do so simply shows the modesty and care with which it undertook this task.
What do you think are the limits on how far the Commission could go?
The Commission cannot violate a specific directive of Congress. The Commission needs to adopt purposes or reasons that are grounded in the purposes of sentencing. That's Section 994A2. The Commission's interpretation.
You said it can't contradict a specific direction from Congress. Which specific directions would limit it?
Well, for example, if the Commission were to say that rehabilitation alone were an adequate factor.
What beyond that?
There were questions earlier about whether the Commission could say you, district court, may disagree as a matter of principle with mandatory minimums. And we would say that would be a violation of the specific directive of Congress, that is a reasonable punishment for that offense.
Mr. O'Neill, same question that I asked Mr. Frederick. If your position is right, does the inquiry into sentence disparities in these gun cases start to look a lot like the inquiry into sentencing disparity in the crack cocaine cases? And if it does, is that odd given the textual difference between Section 403 and Section 404?
The analysis is completely different between the crack cocaine cases and the kind that are covered in B6. The Federal Defender's Brief does an excellent job of explaining how different these procedures are. With 404, which was an actually retroactive law, district courts set up standing orders. Defendants were waived through because there was no question at the eligibility. As to eligibility, it was all about the 3553A factors. Here, every case is considered on its individual facts. the courts exhaustively look at the prisoner's individual circumstances, and the statistics bear out this difference.
What limits would you put on the Commission's authority to describe what a compelling interest is or what an extraordinary circumstance is?
Well, I don't think that they can simply disagree with Congress or authorize individual judges to
can they do that? What I'm hearing is that in standing alone, they cannot disagree with Congress. That's what I'm hearing from the other side. But if it's a part of a totality of the circumstances inquiry, then they can disagree with Congress.
And I think the fundamental problem with that, Justice Thomas, is exactly what I just said, which is that it's a form of judicial parole. If you think back to what I said in the last case, essentially we are taking as a given that the other circumstances, the other reasons, are not in themselves something that would warrant a sentence reduction. They're not extraordinary and compelling enough. What gets them over the line is the fact that Congress adopted a non-retroactive change in law that it explicitly decided not to apply to prisoners in their circumstances, and that is what gets them consideration of these other factors that wouldn't be enough on their own.
So what do you say to the argument that it's not necessarily a direct attack, a disagreement with Congress, but rather the effects of the provision, say, for example, non-retroactivity?
Well, I think this is a direct attack on what Congress did because Congress drew a categorical line, and as the principal opinion in Hewitt recognized, that was partly to prevent all the relitigation concerns. I think the fact that, as my opponents acknowledge, these are even more burdensome to litigate than Section 404 adjustments to sentences, which Congress expressly did make retroactive, is a strike against it. When Congress makes categorical judgments and it wants to allow for exceptions in individualized circumstances, it will enact something like the safety valve, which for mandatory minimums, which it again adjusted. That's in Section 402 of the First Step Act.
You said many times that criteria that would not in themselves qualify as extraordinary or compelling circumstances become so by adding in this, and that's the problem.
So think of it this way, Justice Jackson. It's as though you are weighing something and it has to weigh enough. It has to be.
Your point about Loper-Bright is that discretion has to happen between certain goalposts. And the fact that the First Step Act has imposed a rule of non-retroactivity means that the Commission has exceeded the limits on its authority. So it's not that it doesn't have a lot of discretion, but here it's bumped beyond that.
That's exactly right, Justice Barrett. And I think one problem with their position, and I think it's been well illustrated in the other arguments in this case this morning, is there's really no limiting principle to what they're saying the Commission could do.
In your case, is there any portion of activity that we're talking about that was done at the direction of the military that's involved here?
We don't think so, Your Honor. And the reason is supervision and escorting were left entirely to Fluor under the contract. Once the bomber was hired and was on the base, it was up to Fluor under its contractual obligations to supervise him at his work site as well as to escort him.
And would you spend just a brief moment discussing why Boyle is not dispositive or why it doesn't control here?
Sure. So Boyle is all about a contractor who does what the government says. That is the heart and soul of Boyle. It starts at page 505 by saying the government's interest is in getting its work done. And at step 2, it says there was a significant conflict between state tort duty and what the government required that was precisely contrary to what the government required. And at step 3, Boyle made it very clear that its defense is for contractors who adhere to the government's specifications.
What do you do with the entire text and history of the Constitution, which says war fighting in combat zones is a federal interest, and the states, Article 1, Section 10, and otherwise, have nothing to do with how America conducts its operations in a combat zone?
Certainly, Your Honor. So Articles 1 and 2 do not automatically preempt state law when it comes to federal contractors. And we know that from cases like Penn Dairies and North Dakota. In Penn Dairies, this court said there is no clause of the Constitution which purports, unaided by congressional enactment, to prohibit such regulations, and such regulations there was regulations of military contractors. And of course, Justice Kavanaugh.
Well, in a war zone, though, in a combat zone, we have a line of cases, Garamendi, Crosby, you know all the cases, put aside Boyle. Boyle footnote 4 talks about this, but not Boyle, the rest of it, that says that there are certain areas where there's a uniquely federal interest. And in those areas, the usual preemption rules don't apply, that we expect Congress actually to speak clearly if they want to provide for something like state tort suits. And that's flipped. And it would think if you're talking about uniquely federal interests, there's nothing that's more uniquely federal than successfully fighting a war in a combat zone.
Certainly, Your Honor, we agree that Texas can't declare war on Mexico or New York can't invade Canada.
But can Texas regulate how the military structures its operations at Bagram, or can South Carolina regulate it? And you know, that raises another question here, which is pointed out by Judge Silberman in his opinion on this, which you're familiar with, which is, can 50 different jurisdictions regulate what's going on at Bagram?
Certainly, I'll address in turn. So as to the constitutional structural point, we know the default is common law claims are available. And it goes all the way back to cases like Little v. Barrymee, where Chief Justice Marshall, he upheld damages award against a Navy captain who was following the president's order. And also in cases like Mitchell versus Harmony, there was a common law claim against an Army colonel who seized an American citizen's property during the Mexican-American War in that case. So we do know this is certainly an area where Congress can certainly act, and Congress has done so.
Well, I agree with that, so I don't want this to sound like I disagree with that. Congress can certainly act. The question is, what's the baseline?
So the baseline...
And the baseline, I thought, under our case law going back, way back, if it's a uniquely federal interest, we have lots of cases saying something along those lines, that we require Congress to act to allow such suits. And we've said in, Crosby, for example, a failure to provide for preemption expressly may reflect nothing more than the settled character of implied preemption doctrine that courts will dependably apply. And so Congress looking at this area, the idea that state tort law is going to regulate what goes on in Bagram, I think Congress will be like, sounds way out there, and not something that they need to get involved in because of the doctrine, as Crosby says, that is dependably applied.
Sure. So two responses, Your Honor. The first is the fact that military contractors might face some liability for acts occurring overseas U.S. bases was not lost on Congress. So Congress, in 1941, passed a law called Defense Base Act. And what Congress did there was to exclude or preclude liability for government contractors occurring on U.S. bases as to their civilian employees that are under their supervision. So what that says is the fact that, Congress, of course, operating against a background law like Little and Mitchell, knew that common law had a reach, even on foreign soil. And Congress certainly could have acted to take that back as to when it comes to American soldier who is injured by contractors.
Counsel, isn't the simple answer to Judge Kavanaugh is the 50 states can't tell the military what to do, correct?
Certainly. Absolutely correct, Your Honor.
They don't have – we've already said that in Boyle.
Correct.
And we made it clear. If the military orders them to do something, they have to do it.
Correct.
Military contractors, though.
The military contractor.
Even if you didn't.
That's something else. I mean, what I took from your brief is you're saying Boyle's inconsistent with textualism. Who wrote Boyle?
Justice Scalia wrote
so you're saying the founding father of textualism doesn't understand textualism?
No, that's not what I'm saying at all.
Well, that's what I took. Well, are you willing to? Are there situations in which the Supremacy Clause itself has a preemptive effect?
This court has understood it so. As this court said in United States versus Washington, there are circumstances where the state law directly regulates the federal government, or it discriminates against the federal government or its contractors.
So why wouldn't that apply when what is at issue are actions taken by a military contractor basically on the battlefield, and you want state courts and state juries to decide whether what the military contractor did is justified?
No, Your Honor, first, we're dealing with something that occurred on the civilian part of the base involving
it's
Bagram.
It's a beleaguered.
Come on.
It's a military base in a war zone. And the very fact that there was this terrorist attack there shows the connection with the conduct of the war, doesn't it?
So we're dealing with something that the Army left entirely to Fluor to do. And this is a natural consequence of the fact that Congress knew about contractor liability, but has not limited service members to be able to sue contractors when they're injured.
Now, suppose a contract says that the contractor is to provide appropriate protection when it is accompanying a convoy through a dangerous area. All right, would it claim, and let's say that a member of the military is injured, could that member of the military sue the contractor on the theory that the contractor was negligent?
It depends on what the Army's understanding was, and Boyle contemplates this too, Your Honor. So Boyle says you look first at whether there was a reasonably precise specification, and the step two is whether or not the contractor adhered to that standard.
What if it's just provide appropriate protection?
I think Boyle contemplates litigation over that issue.
Serious?
I was thinking of a similar question to Justice Alito, that you could have the rule that you're suggesting here, and it's the rule that I do think follows from Boyle, which is that the contractor is liable as long as the military didn't specifically approve or direct the conduct. But you could have a more deferential rule, which still allows some forms of state liability to come in, which is that the contractor is liable if but only if the plaintiff can show that the contractor violated military policy. In other words, so in this set of circumstances of the kind that Justice Alito was given, where the government doesn't really say one way or the other, maybe doesn't say anything at all, or maybe leaves it to the contractor to decide, their liability would not be all right. Instead, liability could come into effect only if you could show that the contractor violated military policy. What would you think of a rule like that?
We would certainly be okay with that rule. Certainly, if the court is already thinking about creating some sort of a federal common law rule in this area, we think it should be the one that furthers the government's interests by avoiding contractor negligence and incentivizes contractor adherence in a war zone. And this ended up injuring multiple U.S. soldiers on the base because Fluor didn't do what the Army told it to do. So if we're thinking about what kind of rule applies, the rule has to be one that saves soldiers.
Mr. Chang, as a matter of conflict of laws, why does South Carolina law even apply? And I understand we don't have to decide that question to decide this case, but it does seem perplexing.
Certainly. So part of it is it's largely a choice of Fluor's. Fluor was the one who put a principal place of business in South Carolina. It should be not surprising at all sometimes when you apply choice of law principles that the forum state's law might apply to you. And here, Fluor hasn't disputed our assertion that South Carolina law controls.
Is it possible that Afghan law could apply based on choice of law principles?
It's certainly possible, Your Honor.
So it's possible that a suit against a military contractor in a war zone could be based on the enemy's law.
Which seems bizarre. If this happened on an American base, I wouldn't understand the base to be Afghan soil. I would understand it to be U.S. soil. So if that – seriously?
Certainly. I mean, there are some courts that have – lower courts that have applied Afghan law in situations like this. However, there are certainly other things that factor in as well, like, whether there's an agreement with the –
Doesn't that seem like a pretty big problem for your theory, if that's the state law, if the default is whatever law would otherwise apply, as Justice Kavanaugh is saying, the enemy's law is going to apply to the – I mean, that suggests that maybe a federal common law should apply. Maybe not the common law rule that Fluor and the government won. But if the alternative is a default of Afghan law?
So two responses to that, Your Honor. The first is that so when it comes to applying foreign law to judge the acts of a military contractor, again, that's an ordinary working of the fact that Congress has not displaced state law, which includes the operation of choice of law principles under that state law. And the second is that, this is obviously not an issue in this case because we're solely talking about preemption here, and Fluor hasn't raised any choice of law issues. But there might be other doctrines that preclude the application of foreign law in situations like this.
I was thinking of a similar question to Justice Alito, that you could have the rule that you're suggesting here, and it's the rule that I do think follows from Boyle, which is that the contractor is liable as long as the military didn't specifically approve or direct the conduct. But you could have a more deferential rule, which still allows some forms of state liability to come in, which is that the contractor is liable if but only if the plaintiff can show that the contractor violated military policy. In other words, so in this set of circumstances of the kind that Justice Alito was given, where the government doesn't really say one way or the other, maybe doesn't say anything at all, or maybe leaves it to the contractor to decide, their liability would not be all right. Instead, liability could come into effect only if you could show that the contractor violated military policy. What would you think of a rule like that?
We would certainly be okay with that rule. Certainly, if the court is already thinking about creating some sort of a federal common law rule in this area, we think it should be the one that furthers the government's interests by avoiding contractor negligence and incentivizes contractor adherence in a war zone. And this ended up injuring multiple U.S. soldiers on the base because Fluor didn't do what the Army told it to do. So if we're thinking about what kind of rule applies, the rule has to be one that saves soldiers.
Mr. Chang, as a matter of conflict of laws, why does South Carolina law even apply? And I understand we don't have to decide that question to decide this case, but it does seem perplexing.
Certainly. So part of it is it's largely a choice of Fluor's. Fluor was the one who put a principal place of business in South Carolina. It should be not surprising at all sometimes when you apply choice of law principles that the forum state's law might apply to you. And here, Fluor hasn't disputed our assertion that South Carolina law controls.
Is it possible that Afghan law could apply based on choice of law principles?
It's certainly possible, Your Honor.
So it's possible that a suit against a military contractor in a war zone could be based on the enemy's law.
Which seems bizarre. If this happened on an American base, I wouldn't understand the base to be Afghan soil. I would understand it to be U.S. soil. So if that – seriously?
Certainly. I mean, there are some courts that have – lower courts that have applied Afghan law in situations like this. However, there are certainly other things that factor in as well, like, whether there's an agreement with the – between
Doesn't
the
that seem like a pretty big problem for your theory, if that's the state law, if the default is whatever law would otherwise apply, as Justice Kavanaugh is saying, the enemy's law is going to apply to the – I mean, that suggests that maybe a federal common law should apply. Maybe not the common law rule that Fluor and the government want, but if the alternative is a default of Afghan law?
So two responses to that, Your Honor. The first is that so when it comes to applying foreign law to judge the acts of a military contractor, again, that's an ordinary working of the fact that Congress has not displaced state law, which includes the operation of choice of law principles under that state law. And the second is that, this is obviously not an issue in this case because we're solely talking about preemption here, and Fluor hasn't raised any choice of law issues. But there might be other doctrines that preclude the application of foreign law in situations like this.
In a South Carolina courtroom, right, there's going to be questions about the military. And the military was supposed to prevent him from bringing this stuff onto the base. That wasn't your responsibility, right?
That's correct. And another thing, the escort.
And the military runs a 5K. Right? And anyone who's run a 5K, there are lots of people stacked together at the starting line.
And there was a lot, and just go ahead, there's a lot of disagreement about what it meant that Fluor's duty to supervise. Our position was that it was our duty to supervise to ensure that the employees carried out the work that they were supposed to do to fulfill the obligations under the contract, not to provide security, not to provide force protection. That remained the...
Let's say I grant you the combat. Beyond that, how do we define it? Because this isn't going. Once we say that this uniquely federal interest carries the day, why wouldn't someone from, say, our military bases in San Diego or in Norfolk, Virginia, who's servicing aircraft carriers or nuclear subs, why isn't that unique?
Well, I think that the states would have more interest in what's going on in California than they do in what's going on in Bagram. But we're not asking the court to invent a new type of preemption here. We think that when Boyle talked about uniquely federal interests, that's a concept that this court used in Sabatino to say the active state doctrine is an area of uniquely federal interest. And the way the court determined that it was by looking to the Constitution, which it said didn't dictate the content of the active state doctrine. It looked to statutes that said that they provided indirect support for the active state doctrine, but it said the very idea that we have U.S. courts questioning the acts of foreign territories foreign sovereigns in their territory is something that is of uniquely interested to the federal
Boyle didn't say as much. You're making Boyle do a lot of work that I didn't read into Boyle.
I think Boyle is standing on a line of case law that talks about uniquely federal interests as being a source of preemption, that this court has continued to repeat that category as being out there as recently as Casarir and Rodriguez, where the court acknowledged that this is there. And I think this is an easy case for determining that it's a uniquely federal interest because of both halves. The federal power is at its zenith because of the way the Constitution has vested war powers in the federal government, and state powers are at their nadir because it has expressly divested states of those types of powers.
Counsel, I'm interested in the limitation to a foreign battlefield. Does that mean, for example, there are bases where we're operating from in Afghanistan at the same time that would not be in a foreign battlefield because it's not as directly engaged as Bagram was in this case?
Well, the rule that we're asking for would talk about whether there are combatant activities. And we're using the exception in the FTCA as a model. Just as the court did in Boyle, it used a different exception. It was looking at general procurement contracting, and so it was looking at the discretionary function exception. But I think that I would say that most everything that the government was doing, that the U.S. military was doing in Afghanistan in 2016, was likely very closely connected with combat activities. And there's no doubt that respondents' activities at Bagram were supporting the military's combatant activities. And so the E. coli in the lettuce that the troops are eating before they go out on patrols, outside the wire in Bagram, that is arising from combatant activities.
Oh, and what if the E. coli infection takes place 700 miles away in a base that is supporting the activities at Bagram?
I think that that's going to be a question about what it means to arise from the military's combatant activities. We also have the second prong, which is about and just to finish the answer to the first prong, that can certainly extend to people who are supplying the troops, who are on the very front lines. The Johnson decision that my friend referenced from the Ninth Circuit shortly after the FTCA was first enacted recognized that, ferrying ammunition to the troops is something that just helping somebody get ready to wield combat is a combatant activity. And here the question, by analogy, is also whether the contractor was performing within the scope of its contract. And if it was...
Okay, so ferrying the troops, what about preparing the rations and food that is going to eventually be used at Bagram? And there's some, infection at the food plant in, some place in the United States.
Yeah, I think that... I'm not sure how the combatant activities exception in the FTCA has been construed in a context like that. I think that for preemption purposes here, this goes to a question that Justice Barrett just asked, whether this really needs to be overseas. I think for overseas, it's overdetermined that the federal government's interests are at their height and the state's interests are at their lowest, and therefore it's easiest to say when it's an overseas situation and it's, that the E. coli is happening in Afghanistan, then That's where the claim is arising. It's arising from the military combatant activities.
Why isn't Yearsley better understood as a defense than an immunity?
Yes. Well, the court has consistently said that it's an immunity and an immunity from suit. And the rationales that this court and others have given for it is because of the relationship to the sovereign. So it's not
usually
just
the sovereign can't delegate or give away their immunity. And I thought the immunity really is unique to the sovereign. That's the essence of it.
Well,
and it can't be sort of handed off to other folks.
The sovereign's immunity is unique to the sovereign's unconditional immunity. And that's Campbell-Ewald. That's what the court held in Campbell-Ewald, rejecting the rather ambitious argument that contractor was forced to make because they had disobeyed the government's instructions, that contractor enjoyed the government's embracive immunity, as the court called it. And the court rejected that, as I note, because that's true. Your Honor is absolutely correct. The sovereign doesn't hand off its immunity. But there are other immunities, including qualified immunity, that are available to people who perform the government's work.
It still gets back to why is the government, I guess I'm just stuck on this. You said this is across all sorts of government programs. Obviously agree. Why is the government then taking a position that you say will thwart the implementation operations of all these government programs? I'm just not seeing that. And because they're on the other side, it cast doubt on your assertion that all these programs are going to be – obviously, we're going to ask the government this, too.
I was going to suggest that you asked Dr. Joshi that very question. And it is, to some extent, better directed to him. All I can say is that, what's driving their brief, as far as I read it, is this reconceptualization of the long common law history and the idea that, in fact, what this court and others have been doing, but never saying it, is applying some sort of derivative privilege born in the pages of the restatement, and urged, by the way, on this court in Campbell-Ewald, and the court didn't take the bait, urged on the Ninth Circuit in Childs, the 2022 decision. That court didn't take the bait. Repeated here in the CVSG brief in CACI from a few years ago. No one has embraced this thing, and it's not new. It's somewhat new. It's 8 years old. But before that, the government was consistently on the side of its contractors. And again, beyond that, I just have to leave it to the government. If the calculation is about the burden imposed on contractors, the government doesn't really have a perspective on life as a private litigant. They don't have to hire outside counsel.
But couldn't you negotiate for that in your contract with the government, that they cover your litigation expenses?
No, I wish we could. So the Anti-Deficiency Act, of course, prevents us from having an open-ended indemnification. FAR 31.205 prevents any number of litigation costs from being built in. This is a fixed-price contract, as all of these are.
Well, couldn't you fix that into the price of the contract?
No, because the FARs exclude. Very fair question. The FARs exclude these litigation expenses, and if we were to put them in as sort of like overhead or something, that would be a false claim and would expose us to a suit under the False Claims Act. So there again, although it is a real problem for GEO.
I just want to make sure I understand what you're saying. You're saying you cannot price in litigation risk?
Correct. We cannot price in, at least not all litigation risk. It may be possible in some contracts, Your Honor, but as a general proposition, again, it's FAR the Federal Acquisition Regulations, Part 31.205, that greatly restricts our ability to price that in. And as a result, the government and GEO cite the Nawazar case in the Ninth Circuit, where the state of Washington sought to impose its minimum wage law on GEO's operation of the voluntary work program. The Ninth Circuit said that was A-OK, cert petition coming. But the government, in the meantime, suspended, as Judge Bumate noted in his dissent from denial, suspended the operation of the voluntary work program at that facility. The point here is that it's not strictly monetary, Justice Barrett. This also goes to the operation of policy. That is the ICE determination that having a voluntary work program that reduces idleness and encourages cooperation and reduces disciplinary incidents is a good penological policy, has been suspended at that facility exclusively because of the crushing liability that's coming for the contractors.
But when GEO is doing exactly what government officials can do and generally have done, running facilities like this. So imagine you had brought these claims against ICE and specific ICE officials. ICE and the officials could raise sovereign immunity, they could raise qualified immunity, and Westfall Act immunity. And if the district court denied any of those, then they could get an interlocutory appeal. So why shouldn't the rule be the same for GEO? Don't the considerations that justify interlocutory appeal when the suit is against a government official also justify an interlocutory appeal here?
I think it depends on the basis for the suit and particularly in the basis for the defense. So the reason that an ICE employee, and I'll note this court has never held that qualified immunity is a defense to forced labor claims, statutory forced labor claims, but I'll bracket that, assume that ICE employees could get qualified immunity or could assert it. The reason they can do that is what this court has said is that the history and the policy support an immunity from suit. And so if the history and policy support an immunity from suit, then you'll get qualified immunity. And what Fluor
All right. Well, how about the policy? Why isn't the policy the same, policy considerations the same here?
Sure. So what Filarski and what Mitchell say are the policy considerations that specifically justify the immunity from suit is the consideration of wanting government employees to show initiative in the face of unclear law. That is why you would get qualified immunity. That is not why you get Yearsley. Yearsley, in fact, is precisely the opposite of that.
Policy is a dirty word, but isn't something similar to policy what is going on in Mitchell and in the other cases where we have said there's a right not to trial unless a certain requirement is met?
I absolutely agree with that, Your Honor. And Mitchell was before Congress passed a statute enabling the court to create new categories of interlocutory orders through rulemaking and interpret the final decision rule through rulemaking. And what this court has said in Swint, what it said in Mohawk, what it said recently in Microsoft is that now is the proper venue for answering this kind of question. Unless we've previously said that something is a collateral order, if we're going back and forth about empirical questions and policy questions, rulemaking is the proper venue for doing that.
I was just going to ask, we know that this is a defense from liability as opposed to a true immunity. Because why?
Because we view Yearsley through the principal agency concepts in which we do think it's a privilege that's being delegated, but we really think if you look at the substance of what's being delegated, it means that the contractor acts lawfully when it obeys lawfully delegated instructions from the government. And we agree with respondents and what my friend said earlier, which is that an agency doesn't have, like a federal agency, doesn't have authority to violate a federal statute, for example. That's just not something an agency is allowed to do. So I don't think Petitioner is correct to say that the first condition of Yearsley is just whether it's within Congress's constitutional power. Of course, Congress could pass a different statute, but it hasn't. It has passed a certain statute, and an agency is not free to violate it. And I don't think the agency is free to effectually violate the statute by simply contracting a private party to do it for the agency. That doesn't really make much sense. So we think where Yearsley applies – we think the first condition of Yearsley is really about lawfulness. Could the government lawfully do it? And then second, did the government lawfully delegate that privilege to the agent? And that's why we think there's really no gap between successfully showing entitlement to the Yearsley defense and having acted lawfully. We think those Venn diagrams are just circles on top of each other.
Mr. Joshi, is it true that a contractor can't price in litigation risk or seek indemnification for litigation expenses?
Yeah, we don't think that's quite true for a number of reasons. Number one, we do think they can, to the extent they have litigation costs in the background, they have their own in-house counsel, things like that. Those do go into sort of overhead costs, and I think most contractors with all of their overheads will, to a certain degree, price that into their bids, into the contract, and that's generally considered okay. Also considered okay under the FAR is insurance against litigation costs. Those can be a line item in say, a cost-plus contract that could be validly put into a bid, and the government could validly pay it. As far as indemnity goes, OLC has long taken the position that indemnity clauses are acceptable as long as, number one, they are capped, and number two, they are conditioned expressly in the contract as being contingent on there being appropriated funds available at the time the payment is due. So as long as those conditions are satisfied in the contract, even indemnity is okay. Now, I know that petitioner in the reply
on your
briefs—
first point, you mentioned your friend on the other side mentioned the False Claims Act. That's not a concern?
I'm not entirely sure why it would be a False Claims Act violation to say in a contract, here are our overhead costs, and government, you can accept our bid or not.
Okay. Well, I'm sure that'll be used in the future.
Well, I'm just not sure what Mr. Dre is referring to be honest. In my own discussions with my client agencies, I've been told that these kinds of overhead costs typically are just reflective of background costs, and so presumably GEO might be competing with Core Civic, might be competing with others, and presumably if there were large litigation costs as a result of not having an interlocutory, or I shouldn't use the word interlocutory, but not having an immediate collateral order appeal, that would be the delta, presumably. I guess that would just be priced into the contract. We don't see a hesitance on the part of either petitioner or Core Civic or other private contractors in bidding on contracts in circuits, including the Ninth, which is a pretty large circuit, that don't find this to be a collateral order subject to immediate appeal. As we note, to the extent you're thinking, well, maybe it is an immunity from suit, then you would have to answer the question from Will against Halleck, is this important enough to warrant an immediate appeal? Is this more like in digital equipment, in Loro lines, in Heike, in other cases? You would have to ask, is this right being under-enforced, was the word Mohawk used? Are district courts getting it wrong a lot? We don't see evidence of that either. All the cases that petitioner cites on its side of the split have ultimately heard the interlocutory appeal and then ruled against the defendant there. So we just don't see it empirically as a large problem.
It seems intuitively to me, and I'll stop here so I won't have any questions on the Robin, but intuitively, the simple answer was the second answer counsel gave, your co-counsel gave, which was this as a category are cases that are factually interwound often. What was the question? What order did the government give or not give? So isn't that an easy out?
I would love to say yes, and my only hesitance is that I really do think that the case to a large degree depends on whether you view Yearsley as an immunity from standing the burdens of trial, an immunity from suit. Because if it is, then I have to admit, notwithstanding the court's literal text in Coopers and Librand and all the other cases, the fact is sovereign immunity, absolute immunity, and to a certain degree qualified immunity all involved issues intertwined with the merits, and nevertheless they're deemed collateral orders.
That's it for today's High Court Report episode. I hope you enjoyed. If you liked the content, please follow, rate, subscribe, and share. Talk to you soon.